Welcome to the Probate Nation. Probate is a process to transfer the title or ownership of assets to the beneficiary of a deceased person. Not all assets are probate assets, and there are different types of probate, some simple, others more complicated. Like a journey on a slow-moving steam engine train, probate of an estate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets remaining are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probates seem to never end. Our program today takes up a discussion about two types of personal injury claims that arise from time to time that the personal representative of a Virginia estate will need to evaluate and, if merited, pursue with litigation during the course of this probate journey. The first is personal injury to the decedent that arose prior to the decedent's death and did not cause his death. This is called a survival action. The second is personal injury that caused the death of the decedent, and this is called a wrongful death claim. Both are claims the estate may pursue, but as we will learn, while the beneficiaries of each claim may be very different, the steps you will need to take are similar. We are pleased to have with us this evening two Virginia personal injury attorneys to provide insight and guidance as we investigate this topic and learn what to do and when so that you properly lodge your claim and set the wheels in motion to pursue it. Our first guest is a partner in the Metro DC law firm of Coons, McKinney, Johnson, DePaulis, and Lightfoot, where he handles plaintiff personal injury and workman's compensation claims. He's been recognized by various organizations as top 40 under 40 trial lawyer, a top 100 trial lawyer, nationally ranked top 10 under 40 attorney for excellence in the field of personal injury, and one of the nation's top injured workers attorneys. Our second guest practices law with the Fairfax law firm of David L. Marks, PLC, where he focuses on plaintiffs' personal injury cases. Prior to starting his firm, he represented defendants and insurance companies in personal injury lawsuits. He's a member of the Fairfax Bar Association and served as its president from 2014 to 2015. He also is a member of the Virginia State Bar Council as well as the Board of Governors for the Virginia Trial Lawyers Association. Please join me in welcoming Tom McQueenie and David Marks. Guys, thanks for coming in.
Thanks for having us.
I appreciate you guys taking the time to share all your great knowledge. You know, let's just get going with this because there's a lot to cover here. David, let's talk again, like I mentioned at the beginning in my opening. Talk about the difference between a wrongful death claim and a survival claim.
Richard, so you sort of mentioned it in your introduction very well, that simply put, that if a person dies in Virginia as a result of somebody else's negligence, whether a car accident or malpractice from a doctor, that is a wrongful death suit. Whereas in a survival action, if the person is injured and then dies because of something else, that is a survival action.
Okay, I'm glad I thought I understood that. That's good explanation. So Tom, what is an explanation of an example of a wrongful death claim that an estate could sue on?
Well, at its core, any personal injury action has the potential of being a wrongful death claim. But in general, the more catastrophic the accident, the more likely somebody is to succumb to their injuries. Mm-hmm. A good example would be a trucking accident, right? If you can imagine, if you're in a small car hit by a very large truck, in general, you're going to find some of the worst kinds of injuries on the road in a trucking accident. And those injuries can stem from simply broken bones and injured internal organs all the way to burn injuries. Oh my. And oftentimes, particularly if you take into account burns, right? Particularly when they're all over the body and leave one open to infection, you know, the amount of pain that that person goes through during that period of time is just unimaginable. And if they pass away, then their claim changes from a personal injury action, which has those elements of pain and suffering, into a wrongful death claim, in which the beneficiaries under the statute have a claim against the at-fault driver.
Okay. So what is an example then, David, for a talk about a survival claim that an estate could sue on?
Well, let me piggyback on what Tom just said. So let's say that John Smith gets into the trucking accident. and he is in the hospital and he has the burns and he is in agonizing pain for 6 months. But what he ends up dying from is a heart attack that has nothing to do with the trucking accident. So what you have is a survival action, because you can't have a wrongful death action because the death was not caused by the negligence of somebody else.
I see. Okay, good distinction. That's a very good distinction. They've described for me the normal terms. Let's kind of get into some of the nuances here, the nitty gritty. The normal terms that are involved with engaging a personal injury attorney to help somebody pursue a claim, whether it's a survival action or a wrongful death claim.
So as Tom mentioned, both of these are at its core personal injury action. But let's, again, using hypothetical John Smith. John Smith gets into the accident, he retains the attorney. But if John Smith passes away, what you're looking then is his executor, the person that is listed within his will to be the administrator of his estate. That is the person that hires the attorney and can bring a potential lawsuit. And if there is not an executor, if there's no will, the person died intestate, you then look to have an administrator appointed by the court specifically for that survival action or wrongful death action.
Okay, okay. I want to emphasize to our viewers that our conversation today is talking about Virginia wrongful death and Virginia survival actions, okay? We're not talking about other jurisdictions, so the rules may be a little bit different in other jurisdictions. Tom, let's talk about who files the wrongful death lawsuit. So who can bring the wrongful death action?
Well, it's actually designated by statute, and in a wrongful death claim, it's the personal representative for the estate who brings the action in their own name on behalf of the statutory beneficiaries.
Okay. And then what damages are available in that type of a lawsuit?
Well, the damages in a wrongful death claim are different categories. The first is for sorrow, as well as mental anguish and solace, loss of solace. And the elements of solace would be things like companionship and guidance. And then there's a second element of damages, and that would be the more tangible, fungible elements of loss of income, right,
sure.
as well as loss of services, right?
Sure,
so,
that's true.
Particularly if you have a family member who takes care of the household, and now you have to bring in certain help, such as, nannies, right? That's a fungible asset that you can then say, this is the amount of damages we have under this element here. Other damages would include medical bills prior to the passing, funeral expenses, and in very rare situations, there's also punitive damages, right? Punitive damages, though, are very difficult to establish in any personal injury case.
Okay. Now, in the case of a wrongful death lawsuit, who receives the money damages?
Well, there's different categories of beneficiaries, right? The first class of beneficiaries would be any surviving spouse, as well as any surviving children, and in the case of when there's not a surviving child, then if there are surviving grandchildren of that child. The second class would be any surviving parents or siblings, such as brothers or sisters, or relatives who lived with the decedent and depended upon them. Right.
So there's a tier of beneficiaries. And so
there are.
If the beneficiaries are all at that one level tier, then the money just all goes to that tier.
Correct.
So we have to exhaust those people first before we go to the next tier.
Right. But members of a class can elect not to claim or receive these.
Okay,
which,
that's a good point.
Yeah, in situations such as a separated spouse who has had no contact whatsoever with the decedent for a long period of time and had not been relying on them for any financial need, I mean, that would be something that would be beneficial to the other beneficiaries of the estate.
I see. Okay. David, let's talk about who files the survival lawsuit. So tell me about, again, talk a little bit about who files it, and then what are the damages available once they bring that lawsuit and if they actually were going to recover?
So it's similar to the wrongful death, is that you're looking for the personal representative. And as I stated before, what you're looking for is who's listed as the executor in the will. And it's an important distinction between the wrongful death and the survival, is that what you're looking for in a survival lawsuit is the pain and suffering of, again, using our example, hypothetical example of John Smith. We're looking at the pain and suffering that he went through with those burn injuries. Whereas in a wrongful death lawsuit, what you're looking at is the pain and suffering that John Smith's children or his spouse have as a result of losing him. So the distinction is that if John Smith suffered for 6 months with these burns, his case is worth X amount of money. In a wrongful death lawsuit, you're not concerned about his pain and suffering. You're simply concerned how his family reacts to this. And again, if he didn't have any close family, it changes the dynamic of who is claiming and how it's distributed.
Okay. And again, in the case of a survival action, though, who receives the money damages?
And again, so this is an important distinction as well between wrongful death and survival, is that any money, whether it is a settlement with the insurance company or a jury comes back and says we are giving $1 million to the estate, it goes through the estate. So if there is a will, and if John Smith says, I'm not giving anything to my eldest child, everything goes to the youngest child, that's how it's distributed. And Tom can talk more about this, but in a wrongful death lawsuit, especially when a jury decides, they can decide how close that specific family member was and give a distribution that way.
Okay. Well, let's talk about the investigation and lawsuit phase. So Thomas, what information must be gathered to evaluate the merits of these claims?
One of the most important things in these types of cases, particularly when the person who suffered the injuries is no longer there to provide any testimony, is to be able to gather as much evidence and documentation as you can right off the bat, right? Things such as in certain kinds of large catastrophic cases, you may need to have investigators onto a scene of an accident in the short term before the police markings on the ground, for instance, are removed, either by acts of nature or by individuals. You also need to conduct other kinds of investigation. You may need to start gathering medical evidence right on the outset to make sure that things like nursing notes are preserved, and particularly if the decedent had the capacity to fill out anything before their passing, that those are preserved. And doing things like freedom of information requests, it's surprising how much information you can get from those now, including you can get the shoulder cams for the police officers now when they go onto a scene, and their entire investigation could be caught on these cameras, which you can now get through the Freedom of Information Act, as well as dash cams and things of that nature. And you might be able to find witnesses that they spoke to in the beginning that you would never be able to find years later once the litigation process is going through all of its steps.
Okay. Well, that's important, and we want to get that stuff early, from what I understand from our conversation as we prepared for this program. That's very important. David, let's talk about the types of what types of insurance companies are we looking for that are typically available in order to satisfy an award.
So sometimes this is the sad part of the case. I mean, death obviously is sad, but if you know that the person that struck John Smith is at fault for this accident, you know that John Smith had injuries as a result of this accident, and then you're looking to compensate John Smith, how do you do that? So what a good attorney is going to do is look through all the different available insurance. And sometimes the person that hits you doesn't have insurance. What the attorney is going to look for is, was that person employed by somebody? Was that car owned by somebody else? Was that person living with a family member? Was John Smith living with a family member? Because those insurance policies can also apply. And what I would tell your viewers is that buy as much insurance as they can, because just in case they are hit by somebody that doesn't have insurance, that's when your policy comes into play. And it's good to have as much insurance as you can.
Well, I know I was advised many years ago by a dear friend of mine, actually one of your colleagues, about the importance to make sure that you have really adequate uninsured motorist coverage.
Exactly.
So you don't let that be too low because you may need that. So Tom, is there a time period or what they call statute of limitations in Virginia to bring a wrongful death or survival action?
Yes. In the case of survival action, it would be within 2 years of the date of injury. And with the wrongful death claim, it would be within 2 years of the death of the decedent. However, if a personal injury action had already been filed, and then either the plaintiff passes away because of issues having nothing to do with the injuries or succumbs to their injuries, there's no need to file a separate action. They automatically get either changed into a survival action or a wrongful death claim, depending on the circumstances.
Okay. Well,
Richard, if I could jump in for a second. So this is what's interesting about the survival and the wrongful death, is that sometimes the defense attorney doesn't say that the cause of the death was caused by the car accident or caused by the doctor's negligence. And sometimes the plaintiff's attorneys have to go in and they're filing a long lawsuit not only on wrongful death, but also on personal injury. So they need to be cognizant of those different statutes, because you're going in there with both causes of action.
And then you try to consolidate the cases at some point and put them together.
At some point, if the defense doesn't concede one or the other, it goes all the way to the jury, and the jury's going to decide whether or not the cause of death was caused by the accident.
I see.
For instance, in his example of Mr. Smith, the question would be whether or not the heart attack had nothing to do with the injuries, or was it caused by the stress on his body resulting from the burns and the medicine he was taking.
Okay. Well, I know that there's, we talked about when we were preparing for this, that some of the common mistakes that that you run into is that people don't move quickly enough to preserve the evidence, and people get unrealistic expectations about what they're going to recover, and we have to make sure that they understand that there's simply no guarantees in these things, even though it might be that very clear to everybody that someone was the cause of the injury. But let's talk about let's talk a little bit about liens. Okay, there are liens for reimbursement for medical bills that have to be paid when you actually get a case settled. How is that relevant in the claims that we're pursuing here, whether it's wrongful death or for a survival action? How important are the liens?
Well, I think they're more important in survival actions than they are in wrongful death. In Virginia, we have some benefits of being an anti-subrogation state, which means that in general, you don't have to pay back health insurance, right? But there are some exceptions to that. If for instance, Medicare or Medicaid paid for the medical expenses, or it was a federal employee health plan, or it came under what's called an ERISA health plan, which in generally is where the employer or an organization like a labor union provides benefits for health benefits to their employees, but it's not the insurance company who's actually paying it, it's the employer or labor union who's paying for the medical treatment, and just the insurance company is just going in and making adjustments to the bills. Those you would have to pay back. But in a wrongful death case, you may be able to better allocate where the funds go, as opposed to having them be for the medical bills. You can focus more of the recovery on the mental anguish of the beneficiaries, and potentially reduce the lien exposure.
Okay, David, let's talk a little bit more now. Let's go to the judgment and settlement phase. Either we're going to get a judgment from a jury, okay, or we're going to end up settling the case. But how these cases kind of get to that point and what happens varies whether you're a wrongful death or survival case. So talk a little bit about the survival claim, be either what happens with the award, how does it get settled, or what happens with the jury award. Give us a little background on that real quickly.
So quickly, just talking about the contrast between the two. Very simply, in a survival action, if you settle it with the estate, and the personal representative simply signs off on the release. Whereas on a wrongful death lawsuit, if it settles, you still have to come into court, get it approved by the court, and all the beneficiaries have to sign off on it. So any beneficiary that is potential beneficiary of the estate has to be there. If you get a verdict on a survival action, it's very similar to a personal injury action. You get one set amount, and that goes into the estate to be dispersed, and all the bills have to be paid first. Mm-hmm. If you get a verdict in a wrongful death action, they can delineate, again, which beneficiary gets what amount of money, whether or not the medical bills are paid, and so it's very exact by the jury.
Okay. Okay. Well, that's important to understand because, I mean, the wrongful death, that is an issue. You know, we have multiple beneficiaries. They all got to agree. So, well, let's go to some practical advice then about, well, before I could go there, are these recoveries taxable?
No, they're not.
They're not.
No.
That's important to know as well. Let's go to practical advice. Thomas, do you have any practical advice for families who have lost a loved one due to a tragic event like this?
I do, and it really comes down to a perceived stigma that exists within this country about getting the help that you need when it comes to mental health. And when you suffer the unexpected loss of a loved one, get the help you need. Go to grief counseling. See a counselor if you need it. That serves a number of purposes, even outside of the personal injury realm. It will help you deal with the loss, but in the personal injury realm, it will help you understand the grief process, that you can explain it to a potential jury, and also then the grief counselor can be an expert who can speak firsthand as to how it affected you.
Okay. How about yourself, David? Some practical advice.
There's so many moving parts in this, and it's such a traumatic time when you lose a loved one that you need to get an attorney right away. You need somebody that has experience in this. Little things like suing the wrong person or listing the lawsuit as the estate instead of the personal representative, little things that can trip you up and then your family is not taken care of. From the investigative stage all the way to the verdict, you need somebody that knows what they're doing that can take care of your family.
Okay. Well, I know we've covered a lot of material. I know we've had to jump, because there's just so much to be covered here, and I appreciate you guys taking the time. Let's go to some sort of final thoughts you want to share with people. Tom, we'll start with you, that you want to share a big point you want to really emphasize.
Well, in terms of something that to emphasize when it comes to wrongful death or survival claims, at times it's not up to the lawyers who file the claims or the person who brings the claims on what kind of action is going to be ultimately at issue, right? It's going to come down to experts as to what kind of claim you have on your hands and the cause of death. And an attorney can guide you through which form of action would provide your family with the best kind of benefit and try to develop the evidence and medical evidence to go that route.
Okay. David, how about yourself?
Unfortunately, people don't like talking about death, but it happens to us all. And I would tell your viewers that if John Smith had gotten an attorney before his death and taken care of his will, so his family members knew who was in charge, who could bring a lawsuit, that's something to take care of. And then again, after the death, to have somebody in mind, whether it's a family attorney that can refer you to somebody that knows what they're doing in this area.
Okay. Well, guys, I want to thank you both for taking the time and come and talk to us about this. It's an important topic, and unfortunately, more and more people are facing these types of challenges, whether it's a wrongful death claim or it's a survival action. So we've got an aging population, and we're going to see more of these cases in the years to come. Thanks for taking the time to talk to our viewers.
Thanks for having us.
You're very welcome. Without a doubt, probate can be complicated and confusing, but probating an estate in Virginia can involve more than just consolidating bank accounts, paying bills, filing tax returns, and reporting all of that to the local Commissioner of Accounts. In fact, sometimes the only work a personal representative may have to do is to pursue a claim by the estate or family members for damages arising from a personal injury claim, whether it's a survival action or a wrongful death claim. As we learned from our guests, sorting out the facts of a potential claim is best done as soon as possible with a personal injury attorney who can help you understand the merits of a claim and how best to proceed to build and pursue that claim in a timely manner. And of course, remember, it costs you nothing to get that advice at the outset. This brings us to the conclusion of our show on Virginia wrongful death and survival claims. We hope you found the discussion today helpful. Replays of this show and all the shows broadcast to date, along with other helpful information, can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.